All right, everybody, welcome. This is week 3, CJ105 Park at Park University. Uh, Today we're going to talk about, this is going to be a short lecture on parties to a crime and inchoate crimes. Okay, that's what your topic's going to be on your essay this week. Remember, there's 2 assignments this week versus your discussion board. As before, you must answer 2 questions from the discussion board assignment in your own words. Please, in your own words, doing research, answer 2 questions that have yet to be answered by any student. Once all the questions have been answered, you can answer any other 2 you wish. So let's say the first 5 students answer all 10 questions. After that, you can answer any 2 questions you wish. Need to have research. The textbook is a great place to begin that research. However, it is not the only place. And you should certainly look beyond it. This is college. We look, we do research, we verify. So we're looking at things. The web bibliography area of the course has some links to help you get started. The McAfee Online Library is a very useful tool in researching your topics, as well as general web. There are some links, however, and I didn't mention this in the weeks previously, but there are some links, some areas you should not use or must not use. Let's just say must not use for research. Wikipedia, answers.com, yahoo.com, and any of those types of things where anybody can put the information in. You want to get your information from good, verifiable sources. Sources that actually know the topic. Cornell University, Purdue University, Michigan State University, various associations like the International Association of Chiefs of Police, federal agencies, state agencies, and so on. Get your information from some place that has good, accurate information. Those other websites, virtually anyone can put information in those. And oftentimes they're correct. And occasionally they're not correct. And it's your paper. You want it to be correct. Okay, the other part is the essay. The essay, as I mentioned last week, is a short essay, 3 to 5 pages. I really don't count the pages. What I look for is the information. And the primary information I'm looking for is you got to have a title page in APA format. Then you have to have your body of the paper, starting with a 1-paragraph introduction, a discussion of the topics, 1-paragraph conclusion, reference page at the end in APA format. The paper itself must have APA citations within the text of the paper. You will see in the course area a tab on the left side called Plagiarism. Click on that. You'll find information about citations, what's required, reference pages. You'll also find a couple of links to other websites that have sample APA papers. Okay. There's also a set of instructions, written instructions, in the course announcements that explain how to use Microsoft Office Word 2010 to build citations within the body of the paper and create the reference page. Okay? It'll be sufficient for my purposes. So in the body of the paper, what you'll be explaining after your introduction is explaining English common law for the type of crime you've selected, whether it be parties to a crime, criminal attempt, criminal conspiracy, or criminal solicitation. Please do not do everything. Do not do all of them. If you do parties to a crime, there are different things, different types of parties to a crime. You have to discuss all of those. If you're talking about inchoate crimes, pick one of them to do your assignment. Because you have to explain it in what the English common law version was, the common law version. Be sure to define the different elements. Don't just state them, but explain what they mean. Then you have to do research for a state statute or several state statutes if needed. For example, in parties to a crime, most states will have a statute for accomplice and one for accessory. You have to research both of them to get both of those answers. Okay? So you pick a state, you research criminal attempt, criminal conspiracy, criminal solicitation, or if you're doing parties to a crime, you're doing criminal accomplice, criminal accessory. So you research that state, you explain the state statute, you can even quote it. But even after you quote it, explain in your own words what the elements in that statute mean. What is it in just common everyday language is that prosecutor going to have to prove? Finally, do a comparison. How has the state statute changed from the old common law for the particular crime that you've selected to do your research on? Okay? Very brief explanation of the assignment. If you run into problems, if you have questions, be sure to contact me. Let me know. I'm here to help you succeed in the course. Usually these are not very difficult assignments, but be sure that you're doing either parties to a crime or one of the inchoate crimes. Please do not give me a crime against persons or a crime against property. Those assignments are later in the term. So we'll just look at these different topics. We're going to talk about these a little bit here as we go along. Let's start out with parties to a crime. Okay? Parties of a crime involves being held liable for someone else's actions. Right? That's what happens in party to a crime. Now, under common law, we had several different parties to a crime. We had principal in the first degree. Principal in the first degree is the actor, the main criminal, the person who's like, if there's two people go in to commit a robbery, the one that actually commits the robbery is principal in the first degree. Principal in the second degree is a person who is at the crime scene but is not the principal. For example, the getaway driver for a robbery, the lookout during a robbery or a burglary. It's the assistant to the principal in the first degree. This person is there. Their intent is to ensure that the crime is successful. They're there to help the principal in the first degree, who is the main actor. So these two are, their whole intent is to commit the crime and for it to be successful. Then we had accessories. Before the fact. In common law, accessory before the fact was someone who assisted in the completion of the crime but was not at the crime scene. That might be the person who, let's say, the principal and the second decide to go commit an armed robbery. They need a gun. So they go to their buddy and they say, look, we're going to commit a robbery. We need your gun. We'll make sure you get a cut. They take off. Principal in the second sits in the car as a getaway driver. Principal in the first goes in, commits the robbery. All three of these people, their intent is for the crime to succeed. Their intent is to commit a crime. Before the fact, but they're not at the scene. Principal in the second is at the scene and assisting, whether it be as backing up the person in the store that's committing the robbery. Maybe they're in the store with them with a gun as well. But you have principal first, principal, and then we have accessory. After the fact. This is under common law. We have 4 different parties. Accessory after the fact is not only not at the crime, but they don't participate in the crime. They become involved after the crime has been completed. Maybe they hide evidence of the crime, or they help hide out the suspects, the offenders. Their purpose, their intent is not to make sure that the crime succeeds or that there is a crime. They become involved after the crime has been completed. Okay? These 4 under modern law now, having accomplice, and accessory. Okay? Hang on a sec. To make sure. All right. These three have become accomplice. They are ensuring that the crime occurs. Okay, so we got the principal actor. These two are become accomplices because their intent is to commit a crime, make sure it's successful, it's completed, and they're going to benefit from the crime in some fashion. Accessory after the fact today is simply an accessory, and the intent is still the same. They're not aware of the crime before it occurs, or while it's occurring. They find out about the crime after it's happened, and their intent is simply to help the offenders hide the evidence or hide themselves. Whole different intent process, different mens rea involved. Okay, so accessory after the fact, they find out afterwards. Accomplice, they know the crime's going to occur, they know the crime is occurring because they're participating in the actual crime. Now this brings up a big question. When does a crime end? That's a difficult question, isn't it? I mean, some people say, well, armed robbery of a convenience store ends when the person gets the money. What about the escape? That's still part of the crime. They still have to escape. So the end of a crime actually is when the offenders have reached a place of relative safety from immediate police pursuit. That could be a residence, a location. It may be distance. If somebody commits an armed robbery in Smithville, and they get out of Smithville and they drive 40 miles away and they're in Thomasville, well, the police in Thomasville aren't looking for them. They're not in immediate pursuit of them. They're not immediately looking for them. They might be on the watch for them, but it's not like the same type of search that Smithville's having. Okay? So if they get enough distance to where law enforcement isn't actively pursuing them or actively looking for them, then they have reached a place of relative safety from pursuit. Now, if that relative place of safety from pursuit happens to be their friend's house, their mother's house, their sister's house, their brother's house, those individuals then become accessories because they only became involved after the crime ended. It ended when they got to their house. From that point on, there's no immediate pursuit. There's relative safety. The crime has ended. Now, I've had students say, well, the crime didn't really end because there's the investigation and blah, 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 and all those things. Those aren't part of the crime. That's a criminal investigation of the crime. Crimes have a definite ending. Now, some crimes, the end of the crime might be immediately after it's occurred. Okay? I mean, it's possible. I mean, if you commit a homicide in somebody else's house and you leave the house and nobody's aware of the crime yet, the crime ended when you got away from the house because nobody knows you did it and they're not looking for you yet. But it's when they reach relative safety from immediate police pursuit or searching or whatever. The police are not looking for them at that place or that distance away. So we have accomplice, accessory, we have principals, accessories. Now, another type of liability to someone else's crime. Okay, now this is when principal and second, accessories, accomplice, accessories are being held accountable partially or completely for the actions of someone else. We also have something called vicarious liability. Folks, Do not get confused. Do not confuse vicarious liability with these others. These others, these people are actually, these three are actually participating. This one's participating in modern law. This one is not participating in a crime in modern law, neither is this one. But they're being held accountable for a different reason than vicarious liability. Vicarious liability is when we hold someone liable because of their relationship to the offender. All right. Majority of times that's going to mean that the person who's being held vicariously liability, criminally vicarious liability, liable, because they are in a superior position. They're their supervisor, their boss. They're somehow the offender is somehow accountable to that other person. So the other person has some control over them. There's a relationship, usually superior subordinate relationship. Now, many people leave it at that, but we also have to remember that there's mens rea. Okay, mens rea. The person who's being vicariously liable for the actions of another must have knowledge of that criminal activity and benefit from it, or in legal terms we say they should have known because of their position. Okay, so for example, in a large corporation, the corporate financial officer, CFO, is giving out information, insider information on stock, on business coming up that's going to affect stocks. So it becomes insider information. We also refer to that as stock fraud, okay? Securities fraud. If the president, the CEO, knew or should have known what the CFO was doing, the CEO can be held criminally responsible for the same violation. Now, back a few years ago, when many of the loan companies, savings and loan companies and other loan companies and insurance companies got into trouble and put us into the recession, many of the officers for those corporations were held criminally responsible, even though they might not have actually committed an act. But they were in a vicarious position. In other words, they were in a superior position where they should have known what was going on. They should have known that there was an issue, that there was a violation of law. So vicarious liability means that there's a relationship, normally superior over the subordinate who is the actual offender, the principal in the first degree, or just principal in modern law. But because of their position and their knowledge or should have known type of issue, they are also held responsible. You'll find that something as minor as a parking violation. You loan your car to somebody and they park your car someplace illegally and it gets a ticket. You are vicariously responsible for that parking ticket because it's assumed that you knew where the car was going. Now, of course, you can defeat vicarious liability with good defense. If you have good defenses, you might be able to defeat it. But it is a charge that's still there. And as you see, it's different from these because these people are participating. This person is assisting after. This person, who is being vicariously liable for the crime, is not participating. They merely know or should have known that a subordinate was doing something illegal. And they can be held vicariously liable. One of my best examples of this would be, for example, a crime boss in the mafia or the syndicates. One of their sub-lieutenants, because we call their subordinates lieutenants. One of their lieutenants is running a prostitution ring for the mafia. The mafia is the main cheese, the big guy. The Don is benefiting from what the lieutenant is doing. The Don knows what the lieutenant is doing. The Don himself is not doing it. He's not participating. He's not telling them what to do. But he's aware of what's happening. Vicarious liability. Okay? So he wouldn't fit one of these. We can't call him a principal because he's not doing it. He's not at the scene helping do it. So we can't call him a principal. We can't call him an assessor before the fact because he's not doing anything to assist. He's certainly not assisting afterwards, but the subordinate is doing it for the benefit of the Don who is aware. So it's vicarious liability. Now, one type of vicarious liability that is often discussed is vicarious liability of parents and juveniles, or parents and their children. Hang on. Parents can be vicariously liable for their children's actions, but not often criminally. Usually it's going to be civil vicarious liability. Parents can be held civilly liable for the damages and injuries caused by their children in a civil action. Criminally, the only way we can get a parent vicariously liable is if they knew their child was committing criminal acts and condoned it or did nothing to stop it. The parents actually encouraged it, and I have run across some crime families as a law enforcement officer where great-granddad, granddad, dad, and son all committed crimes the same way. They all helped each other. They all taught each other how to do it. So it was, family crime syndicate, if you will. Not petty any crime, but they're all aware. So if they encourage them, they know about it, then a parent might be held criminally liable. But just because your child does something criminal doesn't necessarily mean you will be charged criminally for that same charge, because you can't watch your children 24 hours a day. There's no way for you to know what they are always doing. So we fall into that part. You got to have some knowledge, just as we would with a corporation or any other relationship. But it is based on relationship and knowledge. Okay? So this is the first part. The next part we want to talk about is inchoate crimes. All right, inchoate crimes. There's many of them out there, really. We're going to talk about three of the primary ones, the basic ones that we usually have to deal with in criminal law. First one is going to be criminal attempt. Criminal conspiracy. And criminal solicitation. Okay? Criminal attempt. Criminal attempt is the attempt to commit a crime. We really have an underlying crime of some kind. Every state, and even in criminal law, common law, they define what criminal attempt is. Criminal attempt requires a mens rea of intent to commit a specific crime. In fact, later on when we talk about specific intent crimes, these are all specific intent. In fact, I'll just talk about that here briefly in a moment anyway. Criminal intent, then, you're looking at a specific crime that you want to, that you're planning on committing, and you must have taken some action towards completion of it. Now, under common law, it says that the offender has taken steps towards completion, but is not completed. Once a crime that's intended has been completed, attempt can no longer be charged because we have the actual crime. So they have to have taken steps. Generally what that meant was they have gotten close to completion. So let's say, for example, somebody under common law wants to rob a bank. They will, under common law, they would have been close enough when they pulled into the parking lot of the bank with the intent to rob it. That's close enough. Okay? Under modern laws, state laws, they're going to say things like they've taken substantial steps towards completion. They have gotten to a point where they could not reverse the action. That completion of the crime is imminent. So in my previous example, they pulled into the parking lot. That won't be close enough for modern law. But then they walk up to the front door, they've got a gun in their pocket, they got their mask on, and they grab the front door and they go to open it. Now they have reached attempt, because they have reached essentially the point of no return. They are in the bank. All right, and they've got a gun, they've got a mask. They're not going to be able to back out of this thing and run away real quick. They've reached the attempt stage. So when you're looking at state law, you got to look at sometimes the definitions that have been provided at the end of the statute for how the court has defined the substantial steps or the steps toward completion of that crime. That's what we're looking for. Criminal attempt, pretty much that's what that is. Criminal conspiracy under common law. Criminal conspiracy was two or more people agreeing to commit a crime. Now, two or more, pretty easy. The agreement, that is the part that becomes more difficult to clarify. It takes a little more effort. The two parties or two or more parties must actually have criminal intent. Okay, as I mentioned last week, if a police officer is one of two people agreeing to commit a crime, an undercover police officer, there is no conspiracy, because there's only one criminal mind, criminal intent involved. The officer doesn't have any criminal intent, they have an investigative intent. So now conspiracy is out the window. We don't have two or more people with criminal intent and agreement to commit a crime. The agreement doesn't have to be in writing. The agreement doesn't necessarily have to be verbal, such as, "Hey Joe, I agree with you. Let's go rob the bank." Okay, it doesn't have to be that way. Just merely is that somehow they have joined together to commit the crime. Hey, let's go rob something, and they go to a bank. Okay, they've agreed to commit the other person didn't actually have to say, "Yeah, let's go do that." If they went with them, knowing that a robbery is going to occur, that's sufficient for conspiracy. Now, conspiracy in the old days could not be charged along with the completed crime. So if myself and my next door neighbor decide to go rob the bank, we agree to go rob the bank, we start going towards the bank, and we actually rob the bank, we would not be charged with conspiracy to rob the bank and robbing the bank. However, under some of the more modern laws, conspiracy can be, under, I believe it's called the Wharton decision, can still be charged. But under common law, it's just an agreement. But what is that agreement? Under most modern state laws, we have to have that same agreement. And there's different kinds of agreements. There's wheels, there's chains, there's circles, different styles of agreements that you can look for. But we have to have that agreement between two or more people and an overt act or a substantial step toward completion of the crime. Okay, can't merely just agree. Two people say, "Hey, let's go rob the bank." "Yeah, I agree with it. Let's do it tomorrow." That would be sufficient under common law, but it has not sufficient yet under modern state laws until there is an act. Remember, in our last week we talked about voluntary acts. You have to have an act. And just simply agreeing can be considered an act, but today we want more than that, because if they don't do anything, they're just sitting around drinking beer and say, "Hey, let's go rob the bank." "Yeah, I think we should go rob the bank too," and they just sit there the rest of the day and don't do anything. They really haven't committed a crime. But if they commit an overt act or a substantial step towards completion of that act, then we have modern day criminal conspiracy. Now, an overt act will be defined differently in various states, or the substantial act. They'll define what it is. And just as before, you can say, my state statute requires an agreement and an overt act. Great. What is the overt act? That's the next thing. A prosecutor's got to know what an overt act is. An overt act is going to be something, an action or an act that is designed to ensure the completion of the crime. So if my next door neighbor and I agree to commit armed robbery and we obtain a weapon, we've probably reached the overt act, a weapon for the commission of the crime. We've even gone further if we case the bank out first. We got a gun and we case it, see when are the banks receive money. Excuse me. When the security guards change out or whatever. When does the bank open? When does it close? If it's all part of our planning process and we've done this overt act of casing the bank, we've obtained a weapon, we've got a vehicle, we've committed enough for conspiracy under modern law. Okay? So we want to be able to understand that, pay attention to that when we're researching the state statutes. Criminal solicitation has not changed a whole lot over the millennium. Under English common law, it was simply getting somebody else to commit a crime for you. Now that's different than parties to a crime, because they're actually, accomplices are actually participating. An accessory is helping after the fact. Somebody that solicits does nothing more than get the other person to commit the crime. They're not, the solicitor is not agreeing to commit the crime with the offender, which is conspiracy. Two or more people agreeing to go commit a crime together. Solicitation is, here, I'll give you $500, you go kill my next door neighbor. Okay? I'm not participating. I'm encouraging you to go commit the crime. Generally, under common law, there was some monetary benefit involved. Under modern laws, we generally look at any benefit to the actual actor, offender, from the solicitor is sufficient. Main thing is they are encouraging them to commit a crime. Every so often we'll see a case where an individual, the cases that I normally see are a married woman gets involved with a teenager, for example, or a very young man. And the young man becomes so infatuated that after his married girlfriend, who's quite a bit older, talks him into killing her husband so she can inherit the money and they can be off together. The teenager goes and kills the husband. The wife has committed solicitation. They have solicited someone else to commit a crime. Many people look at prostitution as solicitation because the prostitute is soliciting